I hope the screen is visible to all. Yeah.
Yes, sir.
Yeah. Good evening, doctors. A warm welcome from once again from the team of Microlabs Carsi and SBU. And as you would be observing, this is our second in the series for the program which we are started last month. When we say this as a program, because we have made this session so interesting, a subject which is beyond the regular continuing medical education, because we have added L to that medical education, and now we are calling it as continuing medico legal education. And in the second in the series, we have got our expert, Mr. Amit Karkhan is with us, and doctors who have already attended the previous month's program would have got the introduction about him and his prowess and his expertise in the field of medico-legal things, which are so close to us in the current scenario. Without taking much of the time between him and you, we would have the privilege to welcome him formally. And this time, Mr. Amit Karkanis, who is a practicing Supreme Court lawyer, is going to talk about the second in the series of topic called as Consumer Protection Act 2019. And the introduction to him is, in a brief, I would say, is a practicing lawyer for almost 2 decades with a rich experience in medico-legal laws, surrogacy, healthcare sector, and intellectual property rights. Mr. Amit Karkanis has got a law degree from Mumbai University and a Master of Law degree in International Trade Laws from University of Newcastle upon Tyne, United Kingdom. Further, he has also represented Joint Committee of the Parliament to review and draft the surrogacy laws in India. That talks about his expert things in the medico-legal aspects. And Mr. Amit, it's our privilege that you are here with us for the second time in this session. And I hope today's your session is going to bring up a lot of newer information and useful information to all the doctor fraternity who are here. I would request all the delegates to mute so that the session can go out smoothly. And Mr. Amit, as you would know, Mr. Amit, after the session, he would be ready to answer to your queries. So what we would request all the doctors to just keep on putting in the chat box any queries pertain to the experts answering. Also, there is a point where we would be adding you to the panel where you can directly ask your queries to the legal expert today. Sir, today now the session is yours.
Thank you very much, Mr. Vignesh. And it's always a pleasure and privilege to talk and participate in your continuous medical, education series. And I'm quite happy with the fact that a company like yours is taking this initiative, because medical education is something which is quite new to the pharma sector per se. And I think so it is very important that you use your reach to the doctors, to educate them about latest happenings. So last time we had a very potent topic, and we spoke about income tax and other implications. Medical code of ethics we saw, but today the act that I'm going to speak is directly affecting the doctors. And I personally feel, and I'm sure most of you who are attending today's webinar already know this, that Consumer Protection Act is a one which affects each and every medical practitioner in the country, irrespective of your specialty, irrespective of your place, or even a size of your practice for that matter. So whether you're a general practitioner, or whether you're a surgeon, or you're a specialist, irrespective of your specialty or branch, this act applies to you universally. And it is a revised act which came into effect during corona time. the bill was passed in 2019, but it was given effect in 2020, and the entire act was implemented in 2021, basically. So now we have the entire Consumer Act revised, and the old act is no more on the books of the on the law books. It has been completely scrapped and replaced with this. So this is not an amended act. This is not an amendment. This is a fresh act. It is a new act, and it has got a lot of changes. It doesn't look even 1% of that of the old act. And as you can see, the first Consumer Act was almost 3 decades old, which came into effect in the year 1986. Now, 1986 was a year when we had only Doordarshan. We never had any private television channels. Internet was not there in India. And the only thing that a consumer would probably do is go to a supermarket or a store and buy things. So there was no online, there was no e-commerce, there was no telemedicine, and so hence the act was very redundant. It was old, and hence the new act came into effect, and now the government has completely revised it. The new platforms like your Amazon, Flipkart, and so on and so forth, all the e-commerce platforms are also included now in the ambit of the act. And obviously, when you have an opportunity of passing a new act, the government takes that opportunity to redefine a lot of things in that act. So, so the definitions have changed. The definition of
ಈ
the
ಆಟ ಕೂಡ ಇದೆ.
consumer, the definition of the consumer has been enlarged, and it also now has online offline transactions included by electronic means, teleshopping, direct selling, multi-level marketing. So you name it, and it is now under the ambit of the new Consumer Act. So it is one of the very robust piece of legislation if you are a consumer. Now, as a doctor, you are a service provider. You can be a consumer also. Doctors are also citizens. Doctors are also consumers. You avail of various services yourself in your personal capacity. So, on one hand, if you put yourself into the shoes of a consumer, you will be very happy with this act. Now, as far as doctors are concerned, now we need to see at the end of this presentation. I'm not sure whether you will be happy as a service provider now, because after this new act, there are definitely a lot of implications on the medical profession, the way you practice your medicine, the way you keep your documents, the way you charge. Everything changes dramatically, with this new act. Obviously, in the given limited time that we have right now, it will be difficult for me to cover each and every aspect, but I will try and give you a brief overview of the entire act. And like Vignesh mentioned in his statement, we would then take the question and answers, so that if you have any live examples or if you have any personal issues that you are facing, I will be very happy to help you or guide you in that. So let's first see what are the new things in the new act. So obviously they have introduced a new concept of product liability. Now this is mainly for manufacturers and service providers, basically for to make them accountable for the products that they manufacture and the services they give in maintaining those products, basically. So this product liability concept has been borrowed from American jurisprudence, and they have now included, so manufacturing. May I request everyone to go on mute, please, because it's a little disturbing. So they have added this product liability for every manufacturer, whether it's a car manufacturer, whether it's medical device manufacturer, or whether it's a service provider. So product, if you are offering a specific product to your consumer, then there is this concept of product liability. There is a separate chapter in the new act about product liability. It's a very elaborate concept. Let's not get into that. That may not affect medical practitioners as such. Whatever is affecting the medical practitioners, we are going to see that today first. They have also simplified dispute resolution process with increase in pecuniary jurisdiction of the various levels of the consumer courts. Under the old act, the maximum district level consumer court could deal with was around 20 lakhs. 20 lakhs is a very small amount. If you see, in 1986 it was a huge amount, but now in the year 2023 it sounds to be very less amount. So that's why the pecuniary jurisdiction of the courts, that is the lowest court, has increased now. So what that has resulted in is that the disputes will now be more localized. So one good part of the new consumer act is that it is made life easier for the consumers. You can go to your nearest district forum and file a case up to a limit of 1 crore rupees. Initially, that would have meant that the person would have had to go to the National Commission, which is in Delhi, and National Commission doesn't have circuit benches around the country. So if someone sitting in Tamil Nadu or in Andhra Pradesh would have had to travel all the way to Delhi if he had a claim of above 1 crore. So that saves a lot of time and effort and money for the consumer. Now, whether this helps a doctor or no, we will see that little later. The outright answer is no. So that's why initially only I started by saying that if you are a consumer, you are happy. If you are a doctor or a service provider, maybe you need to wait till my presentation is over. They have introduced additional grounds to file complaint. They have increased the penalties also to check misleading advertisement and adulteration of products. So Advertisement Council of India is there, which is a toothless body, and it doesn't have powers to enforce. But now consumer courts have been given the power to regulate the misleading advertisement, and that is called as unfair trade practice. So if you advertise something and if you can't deliver the standard that you are advertising, then obviously you indulge in an unfair trade practice. So hence now, over and above the medical negligence or deficiency of service, if you are indulging in advertising about a particular service or a product, and if you don't match up to that standard of advertising that you are doing, then there is another aspect or a new angle that has come into effect, is now unfair trade practice. So we have seen lot of advertisements. I have heard a lot of hospitals advertising on radio, and I have also seen them advertising on billboards, or they have especially in the magazines or in a digital platform like Twitter or Facebook or Instagram now. Basically, Instagram is now the most happening form of social media. Facebook is quite outdated, it seems. I still use Facebook, but it seems that now Instagram is you have the short reels and everything. I see a lot of doctors online on Instagram making short videos and clips and everything. Obviously most of them are educational, so those don't attract these liabilities. But if you are advertising a particular setup, or if you're advertising on a radio saying that I've started this huge multi-speciality hospital, we have 24-hour service, we have this, we have that, we have this equipment, that equipment, and if all of a sudden patient comes and finds that there is nothing there, or it is not matching the standard, then obviously you have this new unfair trade practice angle coming into effect. So your advertisement also, or your advertisement campaign also, will have to now go through some sort of a legal check, through your legal departments. If you are running a hospital, I'm sure you must be having a law officer or a legal representative whom you must be going to. So suggestion number one here is to get your advertisement campaign weighed with them, basically. Now, a couple of new things they have established. There is a chapter on product liability. Establishment of mediation centers are there. So every district forum, every district consumer forum will now have a mediation center. They are encouraging people to settle the matter out of the court, which means that if a case goes to a consumer forum and if the judge feels that this can be settled outside, then there are mediation centers which have been provided everywhere. Mediation centers are run by expert mediators, senior lawyers, retired judges, and a lot of domain expertise. You may have chartered accountants, you may have mechanical engineers, architects for construction related contracts, builders, so on and so forth. It could be anyone, even a doctor can be on a mediation panel. But unfortunately, medical legal cases are out of the ambit of mediation as of now. But a lot of people are lobbying that even medical legal cases going to the consumer forum should be referred to mediation. They have introduced video conferencing facility. Now this provision is made in the law, but it has not yet come into effect. But online filing they have started taking. There is this Grahak Suvidha portal which they have created, where you can file online complaints and it directly goes to the consumer forum of your region. So that happened during the Corona time, but it is yet to be crystallized and visual and and further developed. Since now there is no real threat of Corona as such, so everything is working like the old system. But on paper, at least the video conferencing facility is for hearing. Suppose if you have a matter in National Commission in Delhi, and if you are sitting in Bangalore. Instead of going to Delhi, traveling all the way, staying there, paying very high ticket prices, you can sit in Bangalore with your local lawyer, your friend, your medical legal expert, and conduct a case using video conferencing. But this is on paper as of now. They are still working on it. Penalties have gone up substantially, and e-commerce has been included. Like I mentioned, this is a reputation. So, when can a 1 minute, huh? So when does the doctor come under the CPA, basically? That is Consumer Protection Act. So doctors are held liable under the CPA, not merely because there is an injury to the patient. Let's get this very clear. But because of the fact that the injury was direct result of the conduct of the doctor, there has to be a nexus between the injury and the conduct of the doctor. Now, when I say conduct of the doctor, I mean your treatment. I don't mean your physical conduct, your demeanor, your dress code, the way you talk. No. The injury that the patient is suffering or alleging should be because of your treatment, your direct involvement in that treatment. And that is the most important aspect. That is a real test of medical negligence. So, and obviously, you would be liable only if you have not taken or followed the minimum standard of care as required to be taken in a particular case. So the minimum standard of care that is what is expected. You're not gods. You're not expected to give them fantastic care. You're supposed to give them the minimum standard of care, basically. Doctor can be made liable even for a breach of duty on his part once the patient is able to prove that a doctor was negligent, which in turn resulted in harm or injury. Then only will the doctor be liable under the provision. So the initial burden of proving whether the treatment was right or wrong is on the patient. The patient has to prove that the treatment given to me was not right, or which did not follow the minimum standard, and it deviated from the standard medical practice, or this is not the standard line of treatment that was supposed to be given to me. If that aspect is proven by the complainant or the patient in this case, then only there is a question of doctor being held as medically negligent, or liable under the CPA. Now, let me make this very clear. The Consumer Protection Act is a civil law. It is not a penal law. The worst kind of situation under the Consumer Act is that the court will direct you to give a compensation. It is not the law where you will end up in jail, or you will end up losing your medical license, or you will be held, criminally liable anywhere. So this is a civil law. The compensation is the highest that this act can do to you, basically. So that doesn't mean that we take it lightly, because more than the criminal law, the doctors are sued under the Consumer Protection Act, because it's very easy for a patient to file a consumer case. Hence, though it is a liability of a civil nature, most of you must be having your professional indemnity, you must be having insurance cover. So if tomorrow the court gives an order of a compensation to you, I'm sure your insurance is going to cover that. But still, a order against you by a competent court, even though it is covered by an insurance, is not a good thing, and it is something which you should take it very seriously. So normally doctors are very sensitive. I have seen that they are very worried about their reputation and goodwill in the market. So even though insurance is there, I always get told by the doctors that, sir, do whatever it takes, and we want the best type of defense for us in this, in any consumer case. So a case is a case, a court is a court, and any order against you always goes on a record. So that's why it's always good to be insured. If you don't have professional indemnity as of now, in whichever part of the country you are, in whatever may be the nature of your practice, my second advice to you is please go and take professional indemnity cover. The minimum cover that I have always recommended to doctors now, depending on the area that you live, should be minimum 50 lakhs, maximum it could be up to a crore. The insurance premium is not very high, but the professional indemnity goes a long way in protecting the sudden financial burden that may be thrown upon on a doctor if tomorrow something goes wrong in the consumer court. So some of the definitions that they have added, now these definitions were not there in the old act. So they have added the definition of a person. Normally, Income Tax Act also has a definition of a person. The entire definition of a person under the Income Tax Act goes in 1.5 pages. And here the definition is small and crisp, but it includes corporations, companies, body of individuals, means even associations, whether incorporated, that means whether registered or not registered, or even artificial judicial persons, basically. So here consumer organizations, patients organizations, even though if it is not registered, they are treated as a person, and they can sue a doctor or a hospital for deficiency of service. Services also, the definition has been revised. The description of services provided under that does not include healthcare. Now, I have added this para deliberately because I get this question asked. I am asked these questions on every occasion and in every presentation I make on the CPA. That now, and you must have seen those WhatsApp messages, circulating on your doctors groups and on your friend groups, that now the healthcare is out of the ambit of the consumer. It's not given there, it's not there. So this is a misconception. Okay, what is not there is the example of healthcare under the definition. So under the old act, they had given the definition of a service, and they had given 10 services as an example. Okay, and in that there was this example of healthcare. Okay, there were air travel industry, there were hotel industry, healthcare was also there. They had given 10 examples of what amounts to an example of services. Now, the only favor that they have done to doctors in this new act is they have dropped that healthcare word from the the list of examples. So just because it has been dropped from the list of example doesn't mean that you are out of the ambit of the Consumer Protection Act. So if you see the description of services, it is very exhaustive. What it means is that in the long and short of it is that if you take money from someone for treating someone, then you are a service provider. So for example, if I am a patient and if I pay one of the doctors on this panel for consultation, or I get admitted to one of your hospitals and I pay your room charges, I pay your service charges, I pay your medicine charges, I pay your bill. And irrespective of the fact that you may have given me some discount, that doesn't absolve you. Okay. So the moment I pay, I become a consumer and you become a service provider. So that is what matters. So if you have not taken the money for any treatment, then that's a different aspect. We can fight on that ground. But if you have taken money and treated me, then you fall under the definition of service provider, and hence you fall under the Consumer Protection Act. So whether the healthcare service definition example is there, not there, it is irrelevant. What you need to see is the definition, and in that definition they have made it neutral. They have made it service neutral, which means that tomorrow I as a lawyer can also be sued under the Consumer Protection Act for giving deficient service. But right now we are protected by a Supreme Court order. Hence the legal profession is not under the ambit of Consumer Protection Act as of now. But I'm sure sooner or later we will also be made accountable the way doctors are made accountable. But every other service, like whether it's a chartered accountant, whether it's an architect, whether it's engineering services, everyone, and medical services, they are all under ambit of the Consumer Protection Act. So that's why this misconception remove from your mind. If someone has told you, if a very smart person has told you that now this healthcare is dropped from the ambit of consumer, please be rest assured that it is not. And trust me, we are seeing more cases being filed against doctors because the law has made it easier for a patient to go ahead and file a case. Earlier, it was difficult because the patient had to come all the way where the treatment had taken place. But now, with the change in the new act, the patient can sue a doctor wherever he or she wants. Patient, if suppose if suppose your doctor practice in Chennai, and if someone has come from Mumbai to get treated in Chennai and has come back to Mumbai, and if he feels that there is a problem with the treatment, and if he feels that there is a deficiency of treatment, or there is some sort of medical negligence, earlier he had to come all the way to Chennai. He had to travel to Chennai. He had to engage a lawyer from Chennai. He had to deal with the courts in Chennai. But now he can sit in the comfort of his house in Mumbai. He can engage a friend or a lawyer friend of his and fight a case here in Mumbai. So, which means that you as a doctor will have to come all the way to Mumbai to fight the case. I'm not saying you will have to physically come, but you will have to engage a lawyer here. You will have to at least travel once to sign the papers of the lawyers. And plus, obviously, if the court calls you, you may have to come and present yourself before a court. So, this is one of the biggest challenges in the new Consumer Act, that it has made life much easier for the patients. And obviously, because the life of a patient has become easier, your documentation has to now change as per the new act, because it is absolutely essential that you take proper consents. You mention the location of your jurisdiction in the consents. You can you must have admission consent separately. You must have treatment specific consents per different. Every treatment should have a different consent. A blanket consent or a general consent will not do. That's why the new Consumer Act is very, very important. It has virtually given the patient a ready made, well cooked biryani, and he has to just eat it. They have given them everything on a platter, as you may call it. So unfair contracts, now this may not be related to doctors per se, but in general, if you are signing some contract with someone which is unfair, which is one sided, and that also is now covered, a person who is getting aggrieved by such contracts can go to the consumer courts. Now, deficiency in relation to the services. This definition is really very important for us. Rest everything is immaterial according to me, and this is where the entire crux of the act and my presentation is. So, if you see the deficiency in relation to services, so doctors are service providers here. Patient is service taker, that is service receiver. So, hence, if you see the definition, it says any fault, inadequacy, shortcoming in services provided. See, these words are very important. They have shortcoming is such a broad word. It can be interpreted in any way. It also includes any act of negligence, commission, omission by a person which causes a loss or injury to a customer, and even withholds relevant information deliberately. So now the withholding of information is also considered to be a deficiency of service. So what information are we talking here? Here we are talking about indoor case papers. Here we are talking about reports that a patient would want. So even under your medical code of ethics, you are supposed to give the patients their papers within 72 hours. Now that is your personal code of ethics. If you don't give, you can be taken to the medical council for breach of the code of ethics. But now, over and above that, withholding of a relevant information also may be treated as a deficiency of service, and the patient may choose to go to the consumer court also. It is a right of a patient to get all the relevant information in pursuance to a contract or otherwise in relation to any service. The nature of this information is of such a kind that negligence or omission would lead to an injury to a patient. If the doctor does not provide such information, it would be deficiency on his part as defined under the section 211 of the new act, basically. So that is what I meant. So withholding information is extremely dangerous now. If someone comes to you and asks you for their indoor case papers, their test records, their OPD, obviously OPD papers are always with the patients. You don't keep it with you. But if there is an IPD patient and then they want all the papers, I think so you must follow the due process of law and give them all the papers. Obviously, you can review your papers before handing it over. You can see whether you have missed out on anything, and you can just, probably do a pagination of your papers, organize it properly, and then hand it over. I'm not saying that you hand it like a clumsy person, but you hand it over, organize it, and then hand it so that subsequently the patient does not misuse it. Unfair trade practice now, so a lot of people ask me whether is it applicable to the medical profession. Actually it is, I feel. If you see the definition, it says act introduces a broader definition of unfair trade practice, which also includes sharing of personal information given by the consumer in confidence, unless such disclosure is made in accordance with the provisions of any other law. The Act empowers the Central Authority and Consumer Commission to order the perpetrators of such practice to discontinue it. We know that under the medical field, we generate a lot of confidential information, and if you share that confidential information with someone, then that could be treated as an unfair trade practice. This is something which is new, which is evolving. We have not seen many cases under this particular section vis-a-vis hospitals or doctors. But one example I wish to give you here for sharing of information is the online platforms that are mushroomed in India right now. You have a lot of online platforms, aggregator platforms. You have so many IT companies or software companies which have now, developed specialized softwares which actually wants you to share the information of your patient. Now, this is something which you need to be mindful. So the moment you are engaging with such type of a service provider, IT company, or a software, which includes sharing of your patient information, you need to do your documentation very well. If you don't do it, then this fairly and squarely falls under the ambit of unfair trade practice. Because before sharing a patient information or a data, now I'm not saying patient information includes even his phone number and email address. Forget sharing his element, whether he is HIV positive, whether he's got tuberculosis, or whether it has got any other communicable disease, or any other form of disease their patient may be suffering. Sharing that is absolutely under a contract. But even sharing of information like email address or a phone number is also considered an unfair trade practice if the patient has not given you specific permission. So hence your consents, your admission consent at the time of admission becomes very imperative. So if you're an individual doctor, if you're using an online platform which indulges in sharing of the patient data or information, then you must take the permission from the patient or a consent from the patient to share that data. If you don't do that, and if you have some nasty patient coming to you, then he or she may really haul you up under this new provision of unfair trade practice. So it is extremely important that as a medical practitioner, you don't share the data. See, you can do it. You can do everything with the permission of the patient. You don't have to, you can blindly share the data if you take a permission of a patient. You can share it for the research purposes. You can showcase it in a conference as your achievement. You can share it with a third party platform. You can use that in a journal. If you're doing a study, you can use that. But the permission of the patient is required. Anything without the permission of the patient is completely no go with this new definition of unfair trade practices. Now, these are some of the technical things, but they are very important. God willing, I really hope that none of the 154 participants that are there right now here, would have had to face this. But if tomorrow someone files a case against you, consumer forums are divided in three layers. The lowest one is the district commission, which is there in every district in the country. Whichever district you are there, from south, say from southernmost part of the country to the northernmost part, and from the easternmost part to the westernmost part, every district has a consumer forum, and that has a limit of dealing with a case or a compensation claim up to 1 crore. Earlier that was 20 lakhs. So this is very, very important. This because of this one change, most of the medico legal cases, or medical negligence cases rather, will now be dealt by the district level people. Okay, so district commission becomes a very important court for you. It is absolutely, initially all the high profile cases, high compensation cases used to go to Delhi National Commission, or to the state capital, to the state commission. But now, ordinary district commission, the lowest court in the country, will be dealing with the cases up to 1 crore, which is most of the medical negligence cases. Very few of them exceed 1 crore. So most of the cases, almost 75% of the cases now will happen on your local district, which may be good again for the patient. If you are having a localized practice, if your practice area of your pool of patients is only in 1 or 2 districts around you, then this is a good thing for you. But if you have patient coming in from all over the country, then that's something which is really dangerous, because the patient can now sue where he stays. Obviously, earlier, under the earlier law, the district commission or the state commission did not have powers to review their own orders. So that indulged in a lot of cost, where the patient had to go, or a doctor had to go all the way to Delhi for actually reviewing a wrong order. Now that power has been decentralized. All the district commissions have been given power to review. Mediation centers, like I mentioned before, are now going to be there in all the districts. And obviously medical negligence cases are out of the scope of mediation, but everything else is included. But I was told that the government is considering including mediation for medical legal cases also. So if that happens, then I'm sure some of the senior doctors who are listening here may be invited to act as a mediator by a lot of district forums or the state commissions. I'm sure you will start contributing in that way very soon. Pecuniary jurisdiction obviously is increased. Of the state commission has also increased from 1 crore to 10 crores now, basically. And that's why, again, now the state, any complaint where the compensation is above 1 crore but below 10 crores will now go to the state consumer commission. Earlier it was 20 lakhs to 1 crore, so very less cases used to go to the state commission. So that again, obviously state commission has also been given the power to review. Appeal, obviously, initially there was only 30 days timeline given for an appeal. Now it is 45 days. And obviously, if you are appealing as a doctor, if you have been asked by a district commission to pay compensation of 10 lakhs, and if you are not happy with that order, you want to appeal to the state commission, then you have to deposit 50% of the amount in the district commission before the state commission allows you the appeal. So this was also there earlier. It was 25,000 rupees, but now they have increased to 50% of the amount directly. So that again is a very, very burdensome. So you lose the case. That is a first shock. And plus, if you want to appeal against that case, you have to deposit the 50% of that amount in the court. So which means that the money physically comes out of your bank account, and your indemnity comes in little later. But obviously you still end up depositing that money in the court. It doesn't go in the patient's pocket per se, but obviously it goes out of your pocket. So there is definitely a loss of income there. So this again is a provision which is not very comforting for any of the doctors who probably would have lost a case under the new act. National Commission will deal with the cases above 10 crores. And obviously, the deposit of 50% rule is also applicable here. And, they have again revised the appeal rules there. Order against the National Commission, Supreme Court is the final authority. So if you lose in the National Commission, the only court above that is a Supreme Court, and there is no court above Supreme Court, like we all know. So there are 4 layers. So a dispute may start at the district level, and if you decide to contest it, it can go right up to the Supreme Court. And imagine the timeline that it will take for finishing. Can someone put this gentleman on mute, please? Yeah. So the you can imagine the amount of time that will take from the lowest court to the highest court, and that is where again the consumer courts have failed to live up to its expectation. Consumer courts were supposed to be summary courts, quicker courts, but unfortunately they have become like any other court. And now the timeline which we are looking at is almost 10 years. From the lowest court to the highest court, it takes almost 10 years for a case to get over, which is a substantially large period, and I think so. No one has so much of patience to wait and keep that sword hanging on the head of a case being pending. So that's why it's very important that you change the nature of your practice. You focus on documentation. You focus on keeping your records properly, and obviously avoid litigation as far as possible. India is a very litigation friendly country because our laws make it easier for the patients to go to the court, but it is not a very efficient litigation efficient country. We have good laws, but we have very bad legal implementing systems in this country. The courts have, there are tremendous problems. Consumer Forum doesn't have expert doctors as judges. There are only 3 to 4 doctors who have chosen to become judges in the country, and they sit on the consumer benches. So, which means that there is no domain expertise in dealing with medical negligence cases under the Consumer Act. These cases are heard and dealt with by non-doctors who don't understand the entire gamut of medical jurisprudence or the treatment or how the doctor treats a patient. So it is extremely difficult for them to understand how to deal with a medical negligence case. And plus, obviously, infrastructure problems are there, and the number of judges are also less, the number of courts are also less. Lawyers, medical legal expert lawyers are also very few in the country. So that's why it's better to avoid litigation, and that the only way of doing that is probably keeping your documentation proper and taking your law very seriously. ADR mechanism is alternative dispute, it's mediation, but unfortunately, like I mentioned, consumer protection rules have kept matter pertaining to medical negligence or death or injury out of the scope. But we hope that and this is and cases involving fraud, fabrication of document, forgery, impersonation, and non-compoundable offenses are kept out of the mediation rules, basically. So everything else, if you are having a dispute with a bank, or if you are having a dispute with a builder, or if you are having a dispute with your interior designer, whoever it is can go to a mediation, but not the dispute pertaining to death or injury or any medical negligence case per se. We will have to wait for another amendment to these rules, but we hope that it happens very soon. This is a comparative table of what was in the old act and what is in the new act. Though the second point is very important, limitation is the same. So obviously, a case in the consumer court can be filed within 2 years from the date of cause of action, which means that if a patient if you have treated a patient on 1st of January of 2023, and if on the 1st of February 2023 patient realizes that there is an injury, or he feels that there is an element of medical negligence, so the limitation starts from the 1st of February till 1st of February 2023 till 31st of January 2025. So that is the 2 years from the day he comes to know that there is an injury or there is a element of an alleged medical negligence. So limitation is 2 years, but the courts have been given the power to condone that delay. But nowadays, Supreme Court has come out very clearly and said that delay should not be condoned because system is getting clogged by cases, And if you are serious about your injury, if you are serious, if you are a genuine person, then you please come to the court in time. So anyone going beyond 2 years, the court will, in all probability, reject the complaint. And this limitation has to be argued by a lawyer at the time of admission of the complaint. So now these are some of the technical things. Earlier, electronic filing was not there. Now it is been made, and obviously we dealt with this, appeal amounts basically. These are, I think, so we can skip this because video conferencing again is something new. Expert assistance was earlier not specifically provided, but now State Commission, National Commission on an application made by the complainant otherwise is convinced that the case involves larger interest of consumer. It can direct in any individual or organization to assist them in given case. This is very important for doctors. I think so. We have already started using this. We have started involving doctors association or expert doctors, to come forward and give their opinion in a particular medical negligence case. So expert evidence was not specifically provided for in the earlier act, but now State Commission and National Commission has the power to refer a particular case to a particular doctor or an association. So if you are part of any medical association, or if you are part of any specialty association, I think so you should start inviting consumer forum judges for your conferences, because that is where you will be able to increase your rapport with them, and that is where you will be able to sensitize them basically. And the more you interact with the judges who deal with doctors, the more you will more they will understand your problems, and they will keep you in mind if they have any case and if they cannot understand. So here the point is that if you don't go and help your colleague or if your fellow doctor, then in all probability there may be a judgment against him, which may be a wrong judgment medically also, which may be a wrong judgment in many other aspects. But if your expert evidence can help him with a case, then I think so you should come forward, volunteer, and help your colleague who is getting sued by a patient. If you are convinced with his genuinity, with the fact that your friend has not done any negligence, his treatment was right, all the medical protocols were followed, standard line of treatment was given, then there is absolutely no harm in you coming forward and helping your colleague. Because today it is him or her, tomorrow it could be you. So that's why if someone calls you for giving an expert evidence, my humble request to you is that please go ahead, volunteer yourself. You don't have to go to a consumer court. Consumer courts are not like civil courts. You don't have to stand in the witness box. The judge is not going to ask you any questions like you see in the movies. Remove that. The courts are nowhere near what you see in any of the films in the country. Whether it's a South Indian film or a North Indian film, it really doesn't matter. The way they show the courts is completely wrong. You don't get harassed in the court. Okay, so an expert evidence is given on an affidavit. You don't have to physically go to a court. You have to just give an affidavit, and with that one affidavit, your colleague may be saved. So please think about this. If someone comes to you, please help them. Now the challenges which I'm coming to an end of my presentation now, the last 2 or 3 slides. So obviously the new challenges. Liability for medical negligence. Expanded definition of medical negligence makes it easier to file complaint against doctor, resulting in an increase in litigation. This we have started seeing already now. The act came 2 years back, and we have already started seeing I have to now go all over the country to fight cases for my doctors. All my clients are in Maharashtra. I work for hospitals in Mumbai, outside Mumbai, and the patients who come to for a patient who comes for a treatment in Mumbai from outside Mumbai have to have now started filing cases outside Mumbai. So that's why it is absolutely getting difficult for me also to run around. Obviously, but work is work. If I have to go, I have to go. If my client is fine with paying for my fees and for my travel, then I'm more than happy to go. But it increases a lot of headache for the doctors. It is second point is increased paperwork and documentation. Doctors to maintain detailed records and provide patients with written informed consent for all the procedures. Time consuming and adds to the administrative burden. So hospital setup, you have to engage people, you have to recruit people probably to deal with paperwork. You may have to invest in some human resource probably, so that you can actually save yourself from the liability. Stringent standard of care, high standard of care for doctors are set, failing which they can be liable for medical negligence and face severe penalties. Balancing patient interest with clinical judgment, strong emphasis on patient's autonomy and informed consent, which can sometimes conflict with doctor's clinical judgment. So this is extremely important. The new trend which we are seeing now is the patient autonomy. After telling a patient what
I will wait on 2 or 3
Hello. So these are the new things that we are seeing, that the patient autonomy, the view that is now coming forward is that let the patient decide what he or she wants to do. Your job is to explain them the treatment, the options, the alternatives. And in spite of that, if the patient says that we don't want to go ahead, then that is his autonomy or her autonomy. So that's why sometimes you may be faced with a very complex, conflicting situation, but it's better left to the judgment of a patient to take the treatment or no, or to take your advice or no. All that you need to do is you need to make a record of whatever you have done, and you need to prove in the court tomorrow that yes, I had given him or her the following options, and in spite of my counseling or in spite of my explaining, the patient has chosen particular thing to do. So then you're absolved with the liability. So that's why it increases the documentation, it increases your time uh, in administrative work. Fear of litigation, obviously I think so this defensive medicine is the word which we have been hearing a lot nowadays. There is nothing wrong in this, because if the doctor is faced with medical cases, then obviously he or she is going to save himself first. So defensive medicine may be on the rise now. Unnecessary tests and procedures to avoid liability may result in increase in the cost to the patient. So now this is a conundrum, to whether to save yourself from a liability or save the patient's cost. I would always tell you to save yourself. Don't worry about the cost for the patient, because a patient nowadays is highly educated. Patient nowadays is now having a backing of the new Consumer Protection Act, plus the media, plus the social media. You have Google, you have so many tools, you have now artificial intelligence telling you what treatment has to be given. I'm sure you must have heard about Chat GPT and some of the other AI based platforms. There are a lot of IT companies or software companies who are making softwares for the doctors using this artificial intelligence. So tomorrow the time will come probably that even you may not have to refer to a book or a journal. You may just have to ask the artificial intelligence about the particular line of treatment, and the artificial intelligence will write that for you. The same way, whether a treatment was rightly given or no, an artificial intelligence can answer that for a patient. So that's why patient is very smart. Patient has a smartphone in his hand. The access to a smartphone is very cheap. The mobile data is very cheap in this country. So he comes educated with lot of information. So there is no harm in you protecting yourself. So that's why defensive practice is the order of the day, and I see that happening very frequently now. And I don't blame doctors for that, because at the end of the day, act is an act, law is a law, and if you get sued, there is definitely a cost involved for you. And God forbid if you land up losing a case, then there is definitely a problem for you. Reputation management is a big issue. Media trial will happen. A lot of press people are very interested in what the doctors are doing. So that's why doctors, I always keep on saying that doctors are a soft target, and everyone likes to analyze a doctor. More than any other profession in the country, medical profession is highly under the limelight. It is also governed by a lot of laws. You will be surprised that on an average, a hospital in India is governed by more than 35 to 40 laws, different laws. And if you are a private limited company running a hospital, then you have a labor laws also which get added to it, which increases up to 45 to 50 acts basically. And a gynecologist or a radiologist, if you are practicing, then you have so many new laws which have come up now. You have a new law governing IVF in the country now. You have a new law governing surrogacy in the country. You already had the Medical Termination of Pregnancy Act. You already had PCPNDT Act. So there were already lot of laws governing some branches of medicine in the country. And obviously tomorrow it will increase. Organ transplant is also highly complicated in this country. If you are a surgeon who is doing organ transplant, then I'm sure you know what I mean. You need to be registered. Your center needs to be registered. There's authorization committees, hospital level, state level. So many things are there in that. So many administrative functions also you have to do under that. So the long and short and the bottom line is that the times have changed. Doctors, the perception of the doctor has changed. The patient has become very smart. The patient has become very aware. It has become very easy for a patient to cross check your line of treatment. That is what is very important. So the first thing nowadays the patient does is, when you give a prescription, the first thing that they do is they take a screenshot of a petition of that prescription and upload it on a Google to find out what that medicine is. So that's why they know which brand you're prescribing. They know about generic medicines also. So that's why they are highly educated people. And that's why you need to be very careful about what you practice, because the times have changed. The highest liability that a Supreme Court has given for a medical negligence case is about 12 to 13 crores. That was way back in 2013. After that, we have seen a lot of consumer forums increasing their compensations from initially it used to be 5 lakhs, 6 lakhs, 10 lakhs. But nowadays we have started seeing no compensation is below 25 lakhs, 30 lakhs, 50 lakhs. So 10 lakhs and 5 lakhs are history now. So that brings me again to the point of professional indemnity. It's a very important tool for you. Please get yourself insured. If you have not insured so far, please try and get yourself insured immediately. And please keep your insurance, take insurance up to 50 lakhs or up to 1 crore. If you're practicing in big cities like Hyderabad, Mumbai, Bangalore, or Chennai, in whichever part of the country, if you're practicing in tier 1, tier 2 cities, then I think so your professional indemnity should not be less than 1 crore. Thank you very much. And I think so now I have stopped sharing. So if we can take few questions, I'll be more than happy to answer. I've already seen one hand of one Dr. Rajendra Sharma. So,
So there are few questions already mentioned in chat box.
can I see the chat box?
Can I read it out for you, sir? Is that fine?
Yeah, that would be better, Vignesh. I would really appreciate.
I'll do that. First question is from Dr. Path Shah. His query is, who determines the time of realization of injury? For example, say after 10 years of surgery, someone says he has found out that there was a negligence, so as per law, he can file a complaint till 12 years after the actual surgery. Is it so?
No. See, this is again a very popular question, Dr. Shah, you have asked. So actually, there is, whether the case is within the limitation or not is the point that you have to argue before a judge, and the judge decides whether the argument is right or wrong. So the technical aspect is that 2 years starts from the day you realize that there was a mistake, basically. Now, 10 years down the line, if you realize that there was a mistake 8 years back, basically, then that kind of delay is never allowed. So this is a very fantastic probability, though this may be possible on the books. But in reality, looking at various Supreme Court judgments and looking at the trend, this has not happened so far in my 24 years of practice of medico legal now. Though in reality it is possible, but there are a lot of checks and balances which are given in the Supreme Court judgments. So you cannot stretch a logic beyond a particular limit. So if you've done your mathematics and statistics, there is a concept of fantastic probability, and there is a near probability and a fantastic probability. So what is probable is the one which is nearer. Okay. And this is a classical case of a fantastic probability, and we haven't seen that happen so far. But in theory, this question has been discussed many times on many forums. The view of some of the medico-legal experts may differ with that of me, but personally, as a lawyer practicing for 24 years, I have not seen any judge, any court entertaining a medico-legal case or a medical negligence case filed by someone after 12 years or 13 years.
Thank you, sir. And there is another query from Dr. Kiran. Can a consultant countersign a junior doctor notes without writing notes?
It depends who your junior doctor is actually. If your junior doctor is part of your team, and if that junior doctor is aware about the case, if he's involved in the counseling of the patient, if he's involved in the patient management, if he's not BMS or BHMS, okay. If your junior doctor is BMS or BHMS, then please don't blindly sign whatever they write, okay? Because they will not be held liable. You will be held liable if you put a sign without reading what they have written. If your junior doctor shadows you, he sees all your patients with you, he or she is part of your treatment counseling, pre-surgery decision, post-surgery management, then I don't see any reason why you should not sign it. But if you have totally outsourced this work to someone who is not part of your team, then I think so, please don't put your signatures blindly. Please verify what has been written. Please see whether that thing has already been done or no. And then only put your signatures, because your signatures will mean that you will be also liable for whatever is written there.
Okay, sir. Thank you for the detailed explanation. The next question, can patient go to consumer court saying that he was over-investigated, as rightly said that defensive medicine is on the rise? Does overdoing in medicine come somewhere in negligence?
So this is a good question. I'm very impressed with the person asking this question. The answer is no, because two things. There has to be an injury first for you to be held medically liable. So for medical negligence, there is an element of injury. So being overcautious or having a defensive practice may not necessarily cause an injury to a patient, right? It may, that is your clinical judgment. Okay, so before deciding a line of treatment, you have to rule out 1, 2, 3, 4, 5, 6 things. And if you add few more things to that 5 things and you make it 7, there is no harm in that. Okay, because after all, you know your patient better and you can take a call on how much investigations which needs to be done depending on patient to patient. But if there is no injury, then there is no element of negligence. Okay, so the answer to that is no. And I have always encouraged people to, I'm sorry to use this language, but in a very crude way, the only thing that I can explain is that you need to follow save your ass principle. Okay, because we are living in a day and age where patients are so aggressive, patients are so smart. Now, I don't know everyone, the audience in this forum are from which part of the country. I assume that people living in, big cities are more vulnerable than people living in small cities. Okay. But nevertheless, patient who comes to you now comes already pre-decided. So you do whatever it takes to save yourself from any legal liability, which may include ordering or asking them to do additional test. Which is fine, have ordering additional tests is not a medical negligence.
Right, sir. Thank you. Vimal, is there any other chat notice there? Also, I would request any doctor who want to ask a question directly to the expert, you can ask. I think we have already
Dr.
passed
Rajendra Sharma has raised his hand.
Yeah, I could see that.
No,
sir. Yeah. Okay. Sir, Dr. Rajendra Sharma, sir, would you like to ask a query to Mr. Amit? Sir, there is a question from Dr. Venugopala D. You said we have to take consent from patient to share the data. If
Yes.
one second, sir. You said we have to take consent from the patient to share data. If software provider, that is a cloud-based software company, share the data without the knowledge of treating doctor, who is liable? Though software providers say it is encrypted, but I'm not sure about it. Is there any law for the cloud storage software company? We have absolutely no idea where their storage location is all about.
Very, very important, sir. And I am very worried about this cloud people, nowadays. So I'll tell you, there are two aspects to this, sir. This is a very, very important question, and that is where now the work is happening. So in India, we don't have a data protection and a privacy law. We have a bill which was drafted by a retired Supreme Court judge, Dr. Justice B.N. Sri Krishna, and that was submitted to the government for IT Ministry for reviewing. That draft was put up on the website of the government for general public review. Obviously, thousands and lakhs of people said whatever they had to say, and obviously government again sent that for review. So that act has not seen the light of the day. So as we speak, in India, there is nothing as data protection or privacy. And that is what the advantage these people are taking. This cloud people or platform, platform providers basically. But there is a 2011 notification issued by the Ministry of Information and Technology, Government of India, saying that if you are having a data, if you are storing a data, then there is a technical criteria given as to how the server has to be and where the server has to be. Okay, and you need to have a proper agreement with the storage data storage company and the service provider and the doctor, basically. So now, if your platform is not telling you where the data is stored, or they are only telling you it's encrypted, my suggestion to you is that please don't take them for a face value. We don't know we don't know whether their server is protected server or unprotected server. We don't know whether their server is vulnerable for hacking. You must have seen few years back, a lot of servers were hacked by some hackers from North Korea, and a ransomware was put in. So a lot of data were lost, even medical data, not from India, but from other countries, was lost in that. So it is absolutely important for you to ask a very pointed question to these people, that if you want me to come on board with you, you need to tell me where you're storing your data. You need to show me your agreement with the data storage company, and you need to tell me where the location of the data is. Now, just for your information, Amazon and some of the other companies have, and Google also, and Microsoft also, have voluntarily shifted their data centers to India. That was one of the major conditions of the act which was proposed, that your data should not go out of India. So they have voluntarily shifted their servers to India, which is a very good thing. And obviously, if the company is using Amazon Web Services, it has got the highest degree of safety. And there is no doubt about, if your Apple, if your data is stored on Apple iCloud, then also there is a highest encrypted server. But at the end of the day, patient doesn't know your service provider, right? Patient comes to you. And if you share the data and the data is lost, or if someone misuses the data and if the patient comes to know that, then the first person is going to come to you is you. So that's why, again, here, secure yourself with a series of agreements. You need to have a consent from the patient in the first place, that yes, I'm using this platform and I will share your data. So please allow me to do that. That's number one. Number two is, you need to have a proper contract with yourself and the service and your platform provider, the cloud service. So they have to sign a proper agreement with you, and they need to take responsibility for the safety of that data. That is their responsibility. You're not an IT expert. You cannot prevent a malware attack or a spyware attack on a server. So it is the job of that cloud provider. And they need to share the agreement that they had with the data company or data holding company. That is very important. These three things have to be very important. You need to tell your patient, you need to see where the data is stored, and have a proper contract. And wait for the government to pass the new data protection and privacy law, so that our data is protected legally.
Thank you, sir. Dr. Rajendra Sharma, sir, if you have The queries to be asked, you can ask our expert, Mr. Amit Karkani, Dr. Rajendra Sharma, or Dr. C.H. Manoj Kumar. I think you can unmute and talk.
Hello, sir.
Yeah, yes, sir.
Yeah, once, for example, there is a case in district farm and they are given certain judgment and still the patient is not satisfied, want to go to like state level or national level. Our doctor is not satisfied with the judgment. Can any of this either party can go to the higher levels and what is the
Yes, both the parties can go. You can, if the patient is not happy, patient can file an appeal. If doctor is not happy, doctor can also file an appeal, and both the appeals will be heard together by the state commission.
Okay.
It is
So
possible.
there is a query which is mentioned, like in government center, if one has done surgery and post-operative patient is seen by whole team from senior to junior resident doctor. However, if any complication occurs, then who is held responsible? If any emergency, senior person does not come to manage in spite of informing and some complication happened, then what should be done?
So here the principle of captain of the ship is applicable. So if you're a part of a team and so you have Mr. Dr. X's team, Dr. Y's team basically, and patient is referred to you, and obviously in a government setup, everything is a protocol driven. So in a team, the head of the department or the captain of the team or the team leader is the one who is responsible for every action in that department or under that team. So personally speaking, so if you ask me, if you have touched the patient, primary responsibility is of the surgeon or a doctor who has operated or who has touched the patient. But the vicarious liability also falls on the captain or the team leader, because by virtue of being a team leader and a senior, the law expects him to supervise his juniors, and if he doesn't do that, he will also be held or she will also be held vicariously liable.
Right, sir. Thank you. Thank you, sir. Is there any more queries to the expert? Otherwise, we would like to thank him, Mr. Amit Karkani. I think he has taken this time out